much. And so now I will turn it over to my colleague, Mary Ann Blair.
Well, it is my pleasure this morning to introduce our first panel. They're speaking on practicing immigration law in today's climate, changes, challenges, and rewards. And all three of these women have dedicated their professional careers to providing representation to our immigrant community, but also to inspiring and training our law students to do the same important work. Our first speaker will be Professor Bridgette Carr. Professor Carr, as Janet said, is an associate clinical professor of law at the University of Notre Dame, where her research and teaching focus on human rights, immigration, and international refugee law. Her scholarship and clinical work have focused in particular on the plight of asylum seekers, battered immigrants, and victims of human trafficking. Her advocacy for forced migrants earned Professor Carr a 2008 Marshall Memorial Fellowship from the German Marshall Fund. And she tells me that this May, with the funds from that fellowship, she will have the opportunity to study in Europe for approximately 3 weeks, and with European experts in the field of immigration and human trafficking. Prior to joining the faculty at the University of Notre Dame, Professor Carr was Assistant Professor of Law and Director of the Asylum and Immigration Law Rights Clinic at Ave Maria Law School. She's also a cum laude graduate of the University of Michigan Law School, where she was the Michigan Refugee and Asylum Law Fellow with Amnesty International. She earned her bachelor's cum laude from Notre Dame and also worked in private practice as an associate at Miller, Canfield, Paddock, and Stone before joining academia. I'm going to introduce all three speakers now so that we can then just get to the business of the day, which is their presentation. Our second wonderful speaker is Professor Ann Chandler. Ann Chandler is a clinical faculty member who's taught at the University of Houston Center for the Immigration Law Clinic for the past 5 years. I can count right, 5 years. In that capacity, she launched the Juvenile Immigration Outreach Project, which serves immigrant children between the ages of 12 and 17 who've been classified as unaccompanied alien children and detained at the Federal Juvenile Detention Center, Bokenkamp in Corpus Christi. Through this project, law students provide advice to these children and also provide assistance in obtaining pro bono representation. Professor Chandler also assists students in representing clients before the Department of Homeland Security and the Department of Justice in non-employment-based immigration law issues such as asylum, VAWA, family petitions. She educates professionals and the community on policy issues and the law in the areas of asylum, Convention Against Torture, human trafficking, the U visa. She coordinates grants that are used to fund the clinic's community outreach and direct representation to immigrant victims of crime. Professor Chandler came to this job with a wealth of experience. She was graduated cum laude from the University of Houston in 1998 after serving on the Houston Law Review, after receiving the Distinguished Service Award, after earning the Joan Glantz Garfinkel Scholarship for Civil Liberties Research, and serving as president of the Public Interest Law Organization while she was in law school. That organization worked with immigrants detained in Harlingen, Texas. Prior to joining the clinical faculty at her alma mater, she was engaged in immigration private law practice and served as immigration attorney for the YMCA of Houston and also as a bilingual teacher in the Alief School District at the Alief School District. She graduated from Colorado State University magna cum laude, where she received a certificate in Latin American Studies and wrote a thesis on U.S.-Mexico labor relations. And our third distinguished speaker is our own Professor Elizabeth McCormack. We're so proud of our colleague Betsy. She started our immigration rights project, our new clinical program, 2 years ago. And it was a new clinical program, and as Janet mentioned, she and her students have already made the headlines in the Tulsa world for their successful representation of clients in political asylum cases involving religious persecution. Professor McCormack also came to us with a wealth of experience. She was previously a member of the clinical faculty at both the University of Connecticut School of Law and at Cornell Law School. Professor McCormack earned her BA from Fordham, her master's from NYU, and her JD from Georgetown, where she was a senior officer on the Georgetown Immigration Law Journal. Following law school, Professor Mccormack served as assistant defender with the Defender Association of Philadelphia and also, and this is the job I envy, as Assistant Attorney General for the Federated State of Micronesia Department of Justice, where she met her husband in Micronesia. Her teaching and research interests are in the areas of clinical legal education, legal ethics, immigration, and human rights law. So we're very fortunate to have all three of these professors with us who specialize and have worked for years in this important field. And now our first speaker is Professor Carr. Thank you.
Well, thank you so much for having me. Unfortunately, I brought a cold from up north, except I've heard you all have it here too. So last night, for those of us who were honored enough to be able to attend Hiroshi's talk, he talked about the rule of law, and he talked about immigration law, that it should be about systems and not about individuals. And while I won't stand up here and disagree with Hiroshi, I would say that I think when we design systems, people are designing systems. And I think lots of times that the people who design systems are thinking about individuals. And those individuals are often what I've come to call the immigrant in our head. And I think everyone comes here today, when I say the word immigrant, they have an immigrant in their head. And I probably have a different immigrant in my head than you have in your head. And so what I ask for us today to start this conversation is that we take a moment to think about who the immigrant in our head is and how that might affect how we think about law, policy, decision-making, and how that immigrant in our head affects our perspective. I think for a lot of people who are not like Ann, Betsy, and I, who spend our days every day doing immigration law, the immigrant in our head is often someone with a brown face coming from a Spanish-speaking country to the south of the United States, and who is often coming here for economic reasons, to get a job. While that person, and we'll have conversations about that today, may have rights to come here, maybe shouldn't have rights to come here, I want to share a little bit about the immigrants in my head and how they affect the laws that are going to regulate the immigrants in your head. And so I want to start today talking about a young girl that I represent, and we'll call her Amy for this morning. And this talk today was supposed to be about changes, challenges, and rewards in practicing immigration law. And I could identify a change, and I had about a list of 100 challenges, and I tried really hard to think of a reward, and so I think I've got one. But the changes that brought the immigrant in my head named Amy came about in 2000 when the federal government passed the Trafficking Victims Protection Act. It was the first time that the U.S. government at the federal level had passed a law on human trafficking, a federal law on human trafficking in the United States. And that law said that modern-day slavery is illegal in the United States, and we categorize it in two categories. It can be forced labor, meaning people who are forced to be here and work through forced fraud or coercion, who don't get paid, who get abused, that's illegal, and also that sex trafficking is illegal. People who are forced to perform commercial sex acts in exchange for money or something of value, that's illegal, and that if they're non-citizens, that's happening too, that they have a way to stay in the United States to be safe. And that way is called through a trafficking visa or a T visa. And to get a T visa, trafficking victims have to show that they're a victim of a severe form of human trafficking, either sex or labor, and the sex gets a lot more press, I have to tell you, but the labor happens quite often too, that they're physically present in the United States on account of trafficking, that they've complied with requests from law enforcement for assistance, and that it's not enough that you're brought here and that you're trafficked. You also have to show that it would be extreme hardship if you were returned back to your country. So in light of sort of that piece of immigration law, I want to tell you about Amy. Amy grew up in West Africa. She loved going to school. She didn't find that her school was very challenging in her country. And so one day when her aunt came to her house and started talking to her parents about a chance to go to the United States, because her aunt lived in the United States, about going to the United States and going to school, Amy was ecstatic. She begged her parents to let her go. She dreamed of school in the United States. She knew that you could come here and get a fantastic education and be anything that you wanted to be. So, with some pressure from Amy, actually, Amy's parents agreed to let her come to the United States. On that fateful day, as Amy talks about it, she was so excited. She dressed up for her flight to the United States, to the East Coast, and she couldn't wait. She arrived in the United States and was told by her aunt that she needed to go to work the next day. And Amy said, Amy's quite feisty. Amy said, but I need to go to school. I need to get started. I haven't had a lot of school yet, and I need to go. And her aunt said, you need to work for a month in order to make the money for the supplies that you need to go to school. And Amy thought, okay, well, 1 month. I can do it for 1 month. I will work for 1 month. Well, this work was working from 8 a.m. to 1 a.m. to 3 a.m., 8 a.m. to 1 a.m. or 3 a.m., every day, 7 days a week, braiding hair. Now, I've been doing human trafficking work for a while now, and even federal law enforcement officers said that they weren't paying that much attention to hair braiding shops. For those of you in the room who have hair like mine, you might think, how long can it take to braid hair? Well, it doesn't take me very long to braid my hair, but yes, even less maybe from the front row. But for in African American braid shops, a head of hair can take anywhere for a smaller, less complex, wider braid, 1 to 3 hours. But for the tiny little braids, it can take anywhere from 6 to 8 hours. So if your last customer comes at 7 p.m. at night and wants a complex hair braiding scheme done, you're going to be there until really late in the morning. Amy did this every day for a month, and she realized quickly that there was no way that she was ever going to be going to school. Every day when she braided hair, her aunt took all of the money that she made. Some days she worked in her aunt's braid shop. Other days she was taken to other braid shops in the state. And when her aunt's husband would pick Amy up, the aunt's husband would take the money from those braid shops that Amy made that day, and also any tips. Amy learned very quickly that she had to do whatever her aunt said, or bad things would happen. Why did Amy learn that really quickly? Because she was one of 23 other girls that were having this experience at the same time. She knew she would not be going to school anytime soon. She knew that she just had to figure out a way to survive. Amy had a journal that her parents gave her to keep track of her new exciting life in the United States. Her aunt found that journal and took it away from her, but Amy had brought 2 journals because she thought her life was going to be so exciting in the United States that she was going to have to write in the second one as well. And so Amy started keeping track of her life braiding hair, and it's so sad to read when she just talks about the drudgery every day. And Amy would work 8 a.m. to 1 a.m., and lots of times she didn't get to eat until she came home. So this happened for Amy. Amy was 11 when she arrived in the United States. Now, how did Amy get into the United States? Well, Amy didn't enter illegally, if you will. She had a visa. Really wasn't Amy's visa, but Amy didn't know that at the time. What the aunt had done was started buying legitimate visas from people who had once called something called the diversity lottery. It's when you get a visa if you're from a country that doesn't have a lot of people in the United States. So they would go around and purchase these diversity lottery visas, and they would bring the kids in this way. So Amy came in on a quote-unquote legitimate visa. And so Amy didn't know where the visa came from. Amy was just following what her family members said for her to do. And so Amy had this life from when she was 11 until she was 17. When on September 6th of last year, as she talks about it, that she was laying in her bed and someone knocked on the door very loudly, and the uncle went to the door, and men came in with guns and took her away. All the girls were really scared of the men with the guns, and they weren't sure if they should tell them the truth, because Amy has been told the entire time that she's been enslaved in the United States is that people in the United States don't like you. They think you're a criminal. And so you can never tell anyone what's happening to you because they won't believe you. And even if they do believe you, they'll deport you. And if you go back to your country, we'll just get you again. And Amy believed it. Because why wouldn't Amy believe it when all these things have happened to her? Amy finally trusted the law enforcement officers who she told the truth to. And that's where I got the call. I got a call from an FBI agent saying, hey, Bridgette, we just made a big bust, and we have just a couple of clients for you. I said, a couple of clients? I can take a couple of clients. Well, okay, well, it's a little more than a couple. But I know you can do it, and really you're the only person in your region doing this work. So that's how I came to know Amy and 9 other girls who were under the age of 18 who were rescued that night from the house in New Jersey. Now, Amy's story, as compelling as it is, can raise both challenges and rewards in practicing immigration law. One of the rewards in practicing immigration law is that since 2000, we now have a federal law that lets me help people like Amy, that sees her as a victim, that allows a route to protect her. Because if Amy were returned right now to her country, she would be snatched back up. There are threats on the lives of these girls because they are now waiting to testify against the traffickers and put them in jail, hopefully. And so if we can eliminate the girls, we won't have anyone to testify against the traffickers, which means they wouldn't have to go to jail. So we're hopeful that Amy will be able to get a T visa, and under the T visa, if she chooses to, she'll be able to bring in some of her family members. As long as we apply for the U visa in time to bring in certain family members so that she doesn't have to live a life by herself. And that's where one of the challenges of practicing immigration law in this arena comes in. One of the criteria, as I discussed earlier about the trafficking visa, is that it requires reasonable assistance with law enforcement. This requirement doesn't attach to anyone under the age of 18. So as Amy's immigration lawyer, I want to pull the trigger really fast before 5 of my clients turn 18. As Amy's immigration lawyer, though, I also have pressure from federal law enforcement and the U.S. attorney working on this case. They don't want Amy's trafficking visa sent in until the traffickers are prosecuted. And they won't because they don't want any of Amy's information going to the defense for the human traffickers. Well, I'm sympathetic to that. The problem is that if I wait until Amy's 18, I need federal law enforcement to sign a piece of paper for me that says she helped them. And they won't sign it in this U.S. attorney's office until after the case is over. Some of the other cases I've worked on, I've taken them over from other people. And a case I worked on that started in 2000 just got done sentencing last year. These are young girls who have had everything taken away from them. And for me to tell them that they have to wait 7 years in order to potentially even travel to see their family or to have their family with them is just not an option for them. One of the other biggest challenges, sorry, if anyone wants to take this cold with them, I would be really, really happy. Another reward, so that I don't only focus on challenges, is that in the trafficking visa world, I actually collaborate with law enforcement and with the Department of Homeland Security. It's sort of a funny collaboration because any other time in my work, I often think of these people maybe as the enemy in my worst moments. And so it has been rewarding, though, to work collaboratively with FBI and USCIS and ICE agents in order to try to come up with solutions for these people who we both agree need to be protected. That's where my biggest challenge comes in. What I didn't tell you about was that on the night that Amy was rescued, when ICE agents went in, they were prepared for the 20-some girls that they were going to find. They weren't prepared for the 5-year-old boy and the infant that they found in the raid. I didn't know about the infant or the 5-year-old boy for about a month. My clients kept talking about this little boy, and I didn't really know what they were talking about, well, partially because they weren't speaking English, but I just kept hearing this name come up, and after I talked, I realized this little boy was in the house the night of the raid. So I called back to the nice agent who told me I would only be getting a couple of clients, and I said, you know, Amy and all of the others keep talking about this little boy, Miles. Who's Miles? Oh, Yeah, well, the night of the raid when we went in, you know, we had to put people in categories. We had to put people in the categories that matched the immigrants in our head. And we have a category of victim, and then we have a category of undocumented. And Amy and all of the girls fit the category of victim. They said that they had braided hair, that they had swept the floor. Miles had not. We asked Miles, did you wash your own dishes? Miles said no. Well, he didn't because the girls did. They should have asked Miles if he had to pick up his own toys. He would have said yes because he complains bitterly about it. And I said, so where is Miles now? Well, he's in immigration detention. What? You're telling me that you were willing to certify him as a victim if he had washed his own dishes, which arguably is not forced labor, or if so, I should get a T visa too. If he had washed his own dishes. Well, but you know, Bridgette, we just couldn't do it. There was nothing we could do. I said, so you took this kid away from where he was living and put him in jail. Well, it's detention. Okay, yeah, but right, who are the other people there? It's a jail, right? Okay, right. It's a juvenile jail. Okay, fine. Where is he? So I figured out where he was. We made some phone calls, talked about potentially talking to the media. He got out of jail and got put in a foster care placement where all the other girls are in foster care. And you would think that would have been my biggest challenge, right? Getting out of jail. No. My biggest challenge now is that I represent a boy we think is 5, who thinks his name is Miles, who thinks his parents are the traffickers. And this is all I know to be true. His name is not Miles. His parents are not the traffickers. And I know that he came from somewhere in West Africa. And now I get to navigate the immigration system with a kid, a system that at many times is harsh on the people who are in it, with laws that are designed lots of times for the immigrants in our heads who are adults, who come here for economic reasons. And in many ways, this has been my biggest battle as an immigration lawyer, is how to fit Miles into a system frequently designed for economic migrants. Now, luckily, one of the rewards is that because of my relationship with ICE agents, I have bought myself a wee bit of time. The ICE agents have sitting on their desk the notice for Miles to appear in immigration court. Now, for any of those of you who are not as lucky as we are to appear in immigration court on a regular basis, it's often a system where we lose quite frequently. And I had no excitement about walking into a court and saying, "Hi, Judge Hacker. No, I can't stipulate to his name. Nope, can't admit where he came from. Nope, don't really want to talk about his parents. But please don't deport him." That was not going to go very far in front of Judge Hacker. So luckily I found, with the help of some of the other fantastic people who do this area of law, a tiny, tiny little statute in immigration law called the Foundling Statute that says if you are found in the United States prior to 5 years of age, and we're not sure what found means exactly, and you have not yet achieved 21 years of age, and your parentage is unknown, you're deemed to be a U.S. citizen. So on December 23rd, I wrote up a fancy memo to ICE and said, give me some time to do this thing. Now, this thing, the Foundling Statute, has only been done one other time in the history of U.S. immigration law. So I'm not exactly sure how I'm going to do it, but I said to the ICE agent, don't send me that notice to appear. Hold on to it. And I got a wonderful phone call back that said, you just bought yourself until Miles turns 21. Now, that should feel like a victory. However, somehow it doesn't. It doesn't feel like a victory to me because we're working in a system that let Miles go to jail and made Miles dependent on the fact that he was lucky enough that I took those other cases. Because I'm lucky enough to have tons of time to look into those sort of academic, tiny little pieces of legislation. And not everybody is. And he was also lucky enough that we had an ICE agent who, while I wish he would have used his discretion at the day of the raid to put Miles in a different category, wasn't so caught up in what category Miles was in at the time that he's willing to give me some flexibility. So I hope as you go through today and as you go through what's happening in your state, that you can add to the immigrant in your head both Amy and Miles. Because I think as all of us tried to do what Hiroshi talked to us about last night, which is all of us mean well, and all of us are trying to come to the table to seek resolution on a very difficult issue. But I hope you remember that Miles and Amy are part of the discussion as well. Thank you.
Well, thank you for having me, and I am going to follow up with another tale. However, with my tale, there are two problems, and one is I'm not always such a great storyteller. So when you get confused, please raise your hand and pause me and ask for clarification. I also tend to speak in acronyms, which immigration folks do, so please stop me. And second is that I'm going to ask you to help me relate my tale to not only the challenges and the hurdles and the rewards of immigration practice, but to the overall theme of federalism and thinking about what is the proper role of state and localities and the distribution of power, and not just benefits, but enforcement of this immigration law that we find ourselves in. My tale begins in the Newark International Airport with a 14-year-old Chinese boy who, when he was going through secondary inspection, obviously had a falsified passport. At the time of his apprehension, he was under 18 and without the presence of any adults, and so we labeled him in the category of what's called an unaccompanied minor and placed him in a juvenile detention center. It was discovered fairly rapidly that Young's principal problem was doublefold. Number one is he was born in violation of Chinese law. He was not the first child. And his mother, who cared and loved him, had passed away, and he had found himself with his stepmother, who found him an economic and a political burden. And his father and his stepmother entered into a contract with a very interesting group called the Snakeheads. And the Snakeheads is a group that decided with a very small amount of upfront money, less than $2,000, we will agree to provide the documents, the details, the travel, to a destination where you as an individual can enter the United States labor market and work. In this case, it was a New York Chinese employer of a restaurant where you will then fulfill your terms of the contract as working off what amounts to, with interest, roughly $60,000. And the interpretation of the contract from the Snakeheads upon Young's detention in this juvenile jail was that Young did not have to pay $60,000 because he wasn't yet free to reach his destination. But what happened was that because he was a juvenile and our government doesn't necessarily have such strict rules of who must be detained and deported kind of automatically to their home country when it comes to unaccompanied juveniles, he was let out of juvenile jail to the custody of an uncle who lived in Cleveland. And so the Snakeheads, what they did is they viewed that this young kid named Young was their asset. I mean, they'd already invested a good amount of sum in him, so what should they do? Well, it's a rational decision to hire him an attorney. This is what the Snakeheads did. So they hired Young an attorney who went before an immigration judge and tried to make out the case that this individual is going to face discrimination and hardship based on being born in violation of the law. And this case, as you probably, if you know anything about asylum law, completely failed. Asylum law, especially for juveniles, incredibly difficult to win because you must match the harm directly to very narrowly defined groups of a kid's political opinion or religion and nationality. And this is not usually the complex situation which these asylum cases arise from. So when our young was released from jail and landed in his uncle's home in Cleveland, the federal government did that upon 3 conditions. And they said, number 1, you're not supposed to work. You're supposed to go to a local school. You need to attend all your immigration hearings. And when you move, you need to tell all these federal agents. Young agreed, his uncle agreed, and Young went to school. Well, at this point, the snakeheads popped up their head again and say, oh, let me tell you about our interpretation of this contract your father signed back in China. Yeah, you didn't know any money when you were in detention, but now that you're released, what's our expectation? Get over to New York and start working, kid, right? But Young had a different idea. Young had already basically conquered English language while in detention. He was now attending a Cleveland public school with dreams of becoming a doctor and getting straight A's. And his uncle in Cleveland didn't necessarily believe about this debt bondage situation in New York with the restaurant. And so he continued attending school. What played out with the asylum case before the immigration judge? Well, I hate to say it, this is not a story about an unflexible judge or a board of administrative agency ruling indifferently in the sympathetic asylum case. They basically did their job, and there was no claim that was presented at the level of the immigration court, and it was appealed to the federal circuit court. It was denied. So Young was picked up by law enforcement. His attorney didn't bother to inform him, of course, that his case had been denied. And he was brought to the airport. And Young, being a bright man, was very aware from conversations he'd had with both his uncle and his father that the snakeheads had made it very clear what's to happen to Young if they find him upon his arrival in China. And the boy was terrified, because the snakeheads' power and threat of enforcing these contracts has to do with carrying through with some form of punishment for those that don't follow the line. So when Young was boarding the airplane, he decided to bash his head into a cement wall to the point of being unconscious and in a very bad shape. So the federal agency politely and respectfully took him to a hospital, where the University of Chicago has a program of students who went to the hospital to visit him to see what the situation was. And the ICE agent, in fact, called a woman named Maria Wolchin, one of my heroes. And Maria saw the situation for what it was and realized, geez, last week in Houston, there was an immigration conference. And the person who helped kind of put it together and hosted it as a firm was a kind of aggressive partner, young guy named John Sullivan. And John Sullivan had just, in fact, written a group called the National Center for Immigrant and Refugee Children to say, give me a case, I'm really interested in this. And what the National Center is, it's kind of a birth child, in fact, of Sandra Day O'Connor, who visited your law center, I just learned, and Angelina Jolie. And with $1 million of Angelina Jolie's money, who said, you know what, when kids are detained and put, in jail, and they don't have a family member in the United States, and they must go before an immigration judge to try to explain why they're eligible for, staying here, don't you think we should give them an attorney? I mean, this makes sense. The government's got an attorney. The judge is sitting in a black robe. Usually they don't speak the language. They definitely haven't had a law school experience. And so we should do a minimum of trying to find these kids attorneys. And, how many kids are we talking about here? Well, last year, according to government statistics, they apprehended over 100,000 kids. That's like 300 a day of these unaccompanied children. I come from Harris County, and I know we're famous, thanks to the New York Times and other wonderful venues of press, we're famous for our death row cases and the prosecutions and the like. But we're also famous for our housing of these juveniles. I mean, if I drive just from my office, I can visit in one day over 300 of them that rotate in and out. And do they have counsel? No, usually not. So the National Center's goal was let's educate these, these pro bono, these attorneys in these big firms who sometimes are looking for meaning in their lives, and let's get them involved. And in fact, John Sullivan gets his call on his cell phone saying, "Can you help?" "Oh, of course I can help. Sure, tell me about it." Listens to the facts. The kid's in the hospital bed. He's terrified. I'll take the case. We'd set up an arrangement. Whoever takes a case out of this, we're mentoring them. So John then calls me. "Ann, can you help me?" And I just said, "I don't know how to tell you, John, but this is a bad situation. This kid has exhausted his immigration remedies, and he's heading out, and there is not a lot of discretion, flexibility, due process worked into this system that I've figured out how to handle. I have no idea what to tell you, but I do have some numbers and some emails." So before long, within 10 days, he had filed 7 motions in 3 different federal courts and at the Board of Immigration Appeals trying to help this kid's problem. They tried a T visa, as you know, thinking, perhaps they could argue that this kid was in fact on his way to debt bondage. And this is a modern form day of slavery. Did this work? As you rule, one of the first elements Bridgette talked about was you had to be a victim of a severe form of trafficking. Did he even make it to his destination? What about asylum? So we said we need proof. We need contact experts on the snakeheads. And unfortunately, within a day, we found quite a bit of experts and academic support for quite a sophisticated international channel of bringing not only kids but adults into our labor markets. And I think, what does this say about our law enforcement and our ability, whether it's federal or local or state or labor or immigration, to deal with the complexities of this type of labor market in our society, and what kind of reform is needed. We were successful at getting a stay before the circuit court. And to do that, we're trying to document from the home country the factual background of the snakehead's threat. Efforts to communicate with the father were immediately cut off with, "Don't you call this house. You are not a child of mine. You did not obey my orders, and you put me and the rest of our family at incredible risk." And one of the, kind of weird aspects of our immigration law, that was in fact the moment that international conversation was taped with the resources from Fulbright and Jaworski that our office wouldn't have had. That was the turning point in the legal case, because our laws in the area of immigrant juveniles have a very special provision, special immigrant juvenile status, where if a child who is under 21 has been abandoned, neglected, or abused, and a state court judge, or what's called a juvenile court, which could be also a federal judge, that has this power under state law to make best interest findings for a child in a case of neglect or abandonment or abuse, if they find it's not in that child's best interest to return to their home country because of such abuse or abandonment or neglect, that child then can get special findings in an order, what we call a dependency order. And that dependency order can be stapled to some immigration paperwork and sent up to the benefit side of our federal agents to become classified as a special immigrant, be paroled, and then become a legal permanent resident on the road to citizenship. But, and there's a big but in this story, Congress in 1997 added a little one line which said, if a kid is in constructive custody, which means detained or order removal, you got to go first, not to the state court, who's got the expertise and is supposed to look at all the factors and do discovery. You have to go to DHS and get consent. So this is pretty easy. What's the form and procedures? Well, there is no form and procedures because there's no regulations. So, okay, we look at some memos and it's a letter. You send off a letter, say, please give me consent. This situation, here's, the conversation with the father and the like and the experts on the snakeheads, and John Pogash, a single man who was in charge of the decision-making process, who works for the same agency as the one who was actually trying to get our young client on the plane, politely said, "I'm sorry. You know, this kid came here for a better life, to work and to be educated. In fact, we have all the records from his detention, you know, when he was caught at Newark International Airport. And he talked to his dad all the time, and there's really no problems with that relationship. And look at the immigration court proceedings. It has nothing to do with the snakeheads. We think this is contrived. You know, we just don't believe you. Sorry." So we do have a system of checks and balances in the courts. We did file a claim with the U.S. District Court for the Southern District, sitting in Houston, claiming that, in fact, the DHS had violated their duties, their administrative duties, to execute the law, and that their decision under the Administrative Procedures Act was, in fact, arbitrary and capricious. Federal judge, who I should add was a very conservative federal judge sitting in Houston, agreed. Looked at all the facts and said, "Your reasoning is both illogical and inconsistent with the facts," and ordered a 26-page written decision of an injunction which permitted us to then get to state court. In state court, the findings were made that he was in fact abandoned and neglected by his father putting him in this situation, and the kid was on to legal permanent residency. One of the kind of nice rewards in this type of work was that the necessities and the complexities of the law and all the loopholes and motions that had to be filed had this firm who was working during, you know, its summertime with attorneys who knew nothing about immigration law work intensely with their summer clerks. And the team from Fulbright Attorney just kept the laundry list of little email names just get longer and longer. And they just kind of, you know, wrapped their hands around immigration law and immigrant struggle in general. And one of the attorneys of the partnership ended up adopting the child. And at that point, you know, the adoption was necessary to get the kid out of jail before he went up to an adult detention center, but it was also, you know, an act of love, and still lives with the attorney's house. The child went on to get, you know, several free full ride scholarships out of Texas schools. And now the harder part of my talk is, why am I telling this tale in my talk of federalism and the like? And I think there's several reasons, because I really think his tale is not an anomaly in the complexities of the law and how facts don't always, you know, fit into the little punch hole of the T visa, or a victim of a crime, or a U visa, or asylum, or even the Convention Against Torture, which requires a state actor component. And is there acquiescence to the level of the Chinese government that, you know, works with the snakeheads to have a legal theory on that? These cases are complicated. And not very few cases get the attention of a team of bright, young, energetic summer interns and partners at Fulbright and Jaworski. And the majority of these complicated cases never even reach the desk of a pro bono counsel. And how should we take this complexity into account when we start introducing a larger group of actors into immigration law and policy? Let's take Young's uncle in Oklahoma. What kind of laws and the like that would be maybe in place at the local or state level, how would they treat Young's uncle and his actions and his decisions? Third, I think the case also illustrates that immigration as it is not just a set of, you know, immigration provisions. It's a complicated interaction between the feds and the state at many levels, not just with the court system, but also the laws that are in place. I mean, it was Texas laws and definition of neglect and abandonment that ultimately prevailed and decided whether, in fact, Young was eligible to be classified as a special immigrant juvenile. And, you know, at what time would it be appropriate? Young's immigration status moved through various stages. When he was classified and got that state court findings, and then he submitted a form called an I-360, a self-petition to be classified as a special immigrant juvenile, and was paroled in the United States. At that point, was he legal? Would an immigration officer who's just been taught this information to enforce it be able to have the understanding and the like, or the nuances to make rational decisions of what to do with them if they encountered them on our street or at a traffic stop? And so I guess that's the questions I want to ask you. Is there's probably a lot more lessons to be learned in Young's case, and I just want you to kind of think of his case as you hear today's discussions that are going to be at a much more sophisticated academic level than my tale that I tried to tell without too much confusion. So please, during the question and answer, please try to tell me more about how his tale relates to the issues of federalism. Thanks.
Wow, those are two very tough acts to follow, so please bear with me. I'd like to use my time today to talk about some of the current experiences of immigrants and immigrant advocates in Oklahoma, so a little bit closer to home for us. And mindful of the topic of this panel, I'm going to spend some time speaking about some recent changes in the situation for immigrants in Oklahoma and address some of the challenges that these pose, hoping to leave you on an encouraging note of some of the rewards of this kind of work. As many of you know, the Oklahoma Taxpayer and Citizen Protection Act, 1804, passed the Oklahoma legislature with an overwhelming majority during the 2007 session. It took effect on November 1st, or at least the substantial portions of the law took effect on November 1st, and it's a far-reaching attempt to incorporate various elements of federal law related to immigration into Oklahoma state statutes, and to add additional state provisions aimed at ensuring that unauthorized immigrants are excluded from receiving public benefits, jobs, or identification documents. HB 1804 also seeks to have state and local law enforcement officers assume a more active role in verifying the legal status of those entering into contact with the criminal justice system. 1804 has been widely hailed by supporters and touted in the national media as the toughest, most punitive illegal immigration bill in the nation. Of course, that was when it was first introduced. There have been, unfortunately, others that have followed that have tried to be tougher and rougher, so I'm not sure we still hold that status. The law bars undocumented non-citizens from receiving public assistance, penalizes employers who hire unauthorized immigrants, restricts unauthorized immigrants' access to all forms of official identification, and allows local officers to train with federal authorities so they can apprehend undocumented non-citizens. What is going on in Oklahoma in many ways is not unique. State and local government efforts to deal with the unprecedented influx of new non-citizen residents and to respond to the federal government's failure to implement comprehensive and effective immigration reform is at an all-time high. In 2007, state lawmakers introduced more than 1,500 pieces of legislation concerning immigrants, according to the National Conference of State Legislators. That number is up dramatically from 2006, where the number was 550, so 3 times the number in 2007. 240 of these bills became laws in 46 states. The vast majority of the bills were introduced in states that, like Oklahoma, have not historically been the destination of newcomers to the United States, but which in a few cases have in the last decade seen the immigrant community grow at extraordinary rates. Of the estimated 11 to 12 million unauthorized immigrants in the United States today, 2/3 are thought to have entered in the last decade. For Oklahoma, current estimates suggest that of the approximately 180,000 foreign-born residents, as many as 75,000 are unauthorized. Many of the immigration-related state and local laws relate to non-citizen access to employment, education, housing, and public services. For the most part, these laws are aimed at eliminating illegal immigration by limiting or eliminating access to services for unauthorized non-citizens, penalizing citizens who provide services to unauthorized non-citizens, and requiring local officials to cooperate with and report to federal immigration authorities. All this with the goal of getting rid of unauthorized immigrants. As former governor of California, Pete Wilson, famously said in defense of Proposition 187, a California anti-illegal immigration initiative ultimately declared unconstitutional, If it's clear to you that you cannot be employed and that you and your family are ineligible for services, you will self-deport. Along the same lines, Randy Terrell, the state sponsor of 1804 in Oklahoma, had this to say: illegal immigrants will not come to Oklahoma if there are no jobs waiting for them. They will not stay here if there are no government subsidies, and they certainly will not stay here if they know that if they come into contact with one of our officers, they will be physically detained until they are deported. Passage of 1804 has had strong and immediate effects, creating fear and apprehension within Oklahoma's immigrant communities, and uncertainty and concern among those who serve and minister to immigrants about what 1804 does and how it will be enforced. From Tulsa County alone, an estimated 20 to 25,000 non-citizens have left Oklahoma already, though it is by no means clear that these people have self-deported to places outside of the United States. In fact, it seems clear that a significant number of them have relocated to states that are perceived to be safer or more welcoming. And not all of these people who are leaving Oklahoma are unauthorized. As Hiroshi pointed out last night, there are 4 million children in the United States who live in a household with an unauthorized family member. The same thing is true about mixed families living in Oklahoma. A significant number of families have members with mixed immigration status: a U.S. citizen married to an unauthorized immigrant, an unauthorized parent with U.S. citizen children. At the same time, those committed to removing unauthorized immigrants from Oklahoma have been encouraged and emboldened to send even stronger messages that illegal immigrants are unwelcome in Oklahoma. In fact, the sponsor of 1804, Randy Terrell, has recently introduced in the state legislature the Oklahoma Real Immigration and Enforcement Act of 2008. Among other provisions, this bill includes a constitutional amendment making English the only language accepted for all state institutions. The bill would also require Oklahoma school districts to report the number of undocumented children enrolled, as well as the cost associated with that education. A second local law enforcement effort in the wake of 1804, and this is more local to those of us here in eastern Oklahoma, is a Tulsa City Council resolution passed in June of 2007. This resolution directs the Tulsa mayor to order the Tulsa Police Department to inquire into the immigration status of each individual arrested on a felony or misdemeanor charge, and if it's determined that that status is unlawful, to notify the appropriate federal agency. The resolution also declared that a public peace, health, and safety emergency required immediate action on this. As a result, whenever Tulsa police arrest any person for a felony or misdemeanor offense, or encounter during a traffic stop someone without valid identification documents, an immigration status check is conducted. The chief of police and other department officials have publicly stressed that they lack the resources, the mandate, or the desire to investigate the immigration status of anyone prior to detention. However, less than 2 months after the resolution went into effect, and more than 2 months before 1804 even went into effect, the Tulsa Human Rights Commission expressed concerns about a list of detainees from the Tulsa jail indicating that countless Hispanics had been arrested for an improperly displayed license plate, no driver's license, and no proof of liability insurance. The Human Rights Commissioner noted a significant increase in the number of such arrests compared to the prior year and expressed concerns about the appearance of racial profiling. One final development related to local law enforcement involvement with immigrants and immigration law is the final approval in July 2007 of a memorandum of agreement between the Tulsa County Sheriff's Office and U.S. Immigration and Customs Enforcement. This agreement, entered into pursuant to a federal statute enacted in 1996, authorizes up to 40 designated sheriff's deputies to perform federal immigration law enforcement functions, provided that they receive appropriate training and function under the supervision of a U.S. Immigration and Customs Enforcement officer. According to the Tulsa County Sheriff's Department, between September 2007 and February 2008, 30 jail detention officers trained by U.S. ICE have filed 1,200 immigration detainers. A detainer allows law enforcement to keep immigrants detained while they are awaiting to be turned over to Customs and Immigration Enforcement for removal proceedings. Tulsa County Sheriff's Office has also recently entered into an intergovernmental service agreement with ICE, which allows Tulsa County Sheriff's Office, for a fee, to provide detention facilities to approximately 100 incarcerated aliens upon completion of their state sentence pending removal proceedings. In a check of the Tulsa jail inmate list earlier this week, and it's publicly available, 109 inmates had immigration detainers. So the particular challenges that I want to talk about today, there are a lot of challenges posed by these recent changes in immigration law in Oklahoma. The particular challenges that I want to talk about today have to do with the clients that I serve and that my students serve. And those are some of the most vulnerable members of our community. And what I would say about that is that these challenges are they're the result of recent efforts by Oklahoma lawmakers to engage in immigration enforcement, but they're also the result at the same time of the failure of the federal government to pass legislation that responds effectively to an incredibly complex and contentious issue. But a third really important piece to this immigration story in Oklahoma right now is the exceptional increase in the foreign-born population of Oklahoma since 1990. 53% of Oklahoma's foreign-born population has arrived in this state since 1990, an increase that has added to the perception of a crisis here, even if the actual percentage of non-citizens and foreign-born residents in Oklahoma is actually lower than it is in most states. And although the crisis of immigration in Oklahoma and across the country is defined largely as a crisis of illegal immigration, the failure of the U.S. immigration system is equally a crisis for legal residents and U.S. citizens and their families that are caught in the crucible of an often hopeless system that seems designed to prevent hardworking, well-meaning, and often vulnerable immigrants from joining our community. And there's a number of ways in which this plays out for non-citizen victims of domestic violence and other crimes, who are most of our clients. First, the involvement of local law enforcement agencies in the enforcement of federal immigration law and state immigration-related legislation has had a chilling effect on the willingness of non-citizen victims to come forward and report crimes out of fear that interaction with local law enforcement will lead to an arrest for immigration violations. According to the Tulsa Domestic Violence Intervention Services, the number of Hispanic clients seeking orders of protection and pursuing other domestic violence-related legal assistance has dropped dramatically, almost to zero, since the implementation of 1804. Even though DIVIS and the Family Safety Center have a firm policy against revealing the information of a victim's immigration status, awareness in the community of the involvement of the Tulsa Police Department and the Sheriff's Office in immigration enforcement has forced many immigrant victims of domestic violence to make the impossible choice between remaining in a dangerous domestic situation and putting themselves at risk of removal by reporting their abusers to law enforcement. This misperception and fear persist despite the fact that federal law provides relief under the Violence Against Women Act and the Victims of Trafficking and Protection Act for immigrant victims of domestic violence and other crimes. In this respect, the local experiment in immigration regulations has in some ways worked to defeat the purpose of federal immigration law. Related to this, as a result of a provision in 1804 making it a felony for anyone to harbor or shelter non-citizens knowing or in reckless disregard of their immigration status, many domestic violence victims who take the courageous step of leaving their abuser are faced with the prospect of homelessness when they can't find a landlord willing to rent to them because they're in fear of prosecution under the new statute. While it's not clear that anyone has been charged with harboring under the statute, Randy Terrell has been emphatic that it was his intention in supporting the statute that the anti-harboring provision would apply to landlords and others who offer housing to undocumented non-citizens. And although the statute does provide a specific exception for housing by shelters and other emergency domestic violence shelter situations, typically a shelter is a short-term solution for domestic violence victims until an immediate and dangerous situation has passed and until other arrangements can be made. In recent months, helping clients secure safe alternative housing has been a challenge for DV shelter staff since many landlords have expressed concerns about renting to women without proof of legal status. Where the immigrant victim has a U.S. citizen child or two who may also become homeless, the harsh, though perhaps unintended consequences of 1804 are magnified. Relating a little bit to Bridgette's question earlier, who is the immigrant in your head? Probably one of the most difficult challenges for me in representing unauthorized immigrants, and virtually all of my clients are unauthorized immigrants, is getting past the stigma of unauthorized. In so many ways, this status is the scarlet letter of the immigration debate and seeps into and overwhelms every conversation about the worthiness of a non-citizen to obtain legal status. Frequently, we hear cries about amnesty for lawbreakers and a demand that unauthorized immigrants should not be rewarded for their unlawful acts with a chance to become permanent legal members of our community. This unmeasured reaction to the act of unlawful presence or entry is troubling to me. In a former life as a public defender, I rarely ran into folks who believed that my clients, no matter how detestable the crime committed, were defined by their criminal acts, or that these criminal acts were irredeemable and made them unworthy of membership in our community. As a society, we take seriously the notions of fairness and proportionality and mitigation in determining the appropriate response to an individual's unlawful or even criminal acts. We forgive a presidential candidate who admits unlawful drug use in his youth, and even a president with a drunk driving conviction, because we recognize that a single act does not define the character of a person. We consider the totality of the person, his relationships with his family and his community, his service to others, his potential to become a good citizen of our community. This does not mean that every person who commits a crime escapes punishment or penalty. It simply means, as Professor Monomura pointed out last night, that justice requires the exercise of discretion. Should this concept of justice be limited to citizens? Many would argue that this is an appropriate line to draw between citizens and non-citizens. I suggest that it is not, and that a willingness to consider a richer and more complete picture of the unauthorized immigrants living among us. And there are as many pictures of that unauthorized immigrant as there are individual immigrants, that we are much more likely to act with justice in our interactions with them and in any decisions we make about welcoming them into our community. So, in my last 30 seconds to talk about the upsides of the work that I do. Each semester, I work with a wonderful group of TU law students representing non-citizens in immigration matters. We are not a high-volume practice, and the students work very closely and intensively with their clients in an effort to help them obtain lawful immigration status. It's demanding and draining work, but the students are incredibly motivated to help their clients escape persecution, violence, and abuse. As Bridgette pointed out, we don't always win. And in fact, we operate in a system that sometimes seems designed to keep us from winning. But regardless of the outcome, the rewards for our students and for me are significant. Through our relationship with our clients, we are able to come to see the immigrant, authorized or not, as a person, a neighbor, an individual with whom to enter a relationship, rather than the monolithic, faceless other that we see on sound bites on CNN. So, one student and one client at a time, we may be able to begin a new conversation about responding to the immigrants among us. Thank you.
We've run over, but I want to take just a few minutes for questions, and then we'll be sure you get a break to go out and get some coffee or tea. Are there any questions for our panelists?
My question is for Professor Carr. When you're talking about the TV, how realistic is it to expect that there's actually going to be cooperation with law enforcement? There's been such a lag between the time that arrests are made and the family can actually join. It allows for delays in disastrous effects. And I ask that with the background for the Detroit area sex slave organization, where the perpetrator's father and the victim's father both live in the same village. I think she had an idea that something was going to happen to her family if she...
Are you talking about the Cheetah Club?
Actually, I have a sneaking suspicion that you...
I represent that woman,
right.
Yes.
So I'm acting generally.
Right. I mean, I think in general, the question is how realistic is the idea of cooperation for the TV set? Well, in general, it's more than realistic because it sort of has to happen. And in some ways, and I say that because when the women or the kids, or I happen to work with all women or children, are rescued while they really want to be with their families. And I don't want to underestimate that. So for the situation you're talking about now, Katya, one of my clients, did a study abroad program through a university. And when she said goodbye to her family, she only thought she'd be gone at most 3 months. And she can never return to Ukraine because the father of the trafficker has said her blood will run in the streets. Katya's too old to actually bring her parents over the way our immigration law is structured. But for Katya, the first priority is to be safe. And so she knew that cooperation was important and she felt very comfortable with the agents and everything. So I think in the situations I've worked, the cooperation is reasonable. Unfortunately, lots of people are not recognized as victims because they're so afraid they can never do what Amy did in that moment of, can I tell the law enforcement official the truth? So for example, I work with a lot of FBI who talk about, we'll bust these brothels in communities, and everyone who works there says that they want to be there. Maybe. And even law enforcement officials say, I believe that they were victims at one time, but now they choose to stay. And I say, tell me how you can be systematically raped for 365 days, and on day 365, you choose to stay. I don't know how that's possible. So I think the real moment of cooperation for the TV set is that moment where, when you're rescued, whether you sort of fess up to the truth or not, which often determines whether you're classified as Amy or you're classified as Miles. So it's that moment, I think, is often the determining factor.
Thank you.
Yes.
This is kind of a follow-up of that from Carr. When they made that decision to cooperate with law enforcement officials, during that interim time period, they left for school, they wanted to continue granted a temporary work permit.
The question is, what happens in the interim time until they would get a TV set? Well, two things can happen. If you're under age 18, you go into the process that Professor Taylor was talking about as an unaccompanied minor. You're in foster care system. If you're over the age of 18, you're certified as a trafficking victim. And what happens is law enforcement gives you a form of relief called continued presence. And it means you won't get deported and you have a work permit. So there is some things you can do. The downside being the time means you can't get on the path to citizenship, which means you probably can't reunite with your family. You can't do other things. And it's also just, a hard place to be in.
I think we have time for one more question if there are any. No? Okay, then go enjoy your break. Oh, I'm sorry. One more? Yes.
Just a quick question. It's obviously a very emotional topic. And at what point do you put aside the emotion and approach it analytically? Or do you ever reach that point? And if so, what role does the emotion play in the effectiveness of what you do? Or does it detract? Is it a distraction?
I mean, really quickly for me, if I ever do this work and people stop, to me, emotion is humanity. And if it ever stops being about human beings, I need to stop.
I think it's a great question, and it's important for anybody practicing any kind of law to consider how much they're emotionally invested in the work that they're doing and how that's impacting other areas of their life. I agree with Bridgette. If you aren't passionate, if you aren't connecting with the people that you're representing who are sometimes facing the most hopeless situation, and one thing actually that I neglected to mention about the advantage of this, it's not just about it's not just about students getting an understanding of clients or me getting an understanding of my clients. One of the gifts of this work is letting a client know that you care about who they are as a person and that you care about the story that they're telling, and that regardless of what the judge says down the line, that somebody has heard them tell that story, and that means a lot. And so you learn to get a lot of physical exercise and do other yoga is a good thing. But it's a small price to pay for some really great benefits.
And if I could add to that, at least for our law students, this is about skills. This is about going in front of tribunals and officers and telling a story. And to these judges, these administrative judges and ICE agents, they see your client as a number that starts with an A and proceeds with 8 digits. And we have the time and the art of being new at this and having a sense of freshness with the students that they are able to articulate, no, this isn't A99874. We're talking about Yolanda. And let me tell you about it and why it's special. So I think it is that humanity and that sense of being able to individualize and reach out and feel that compassion, which in fact, defines our art and our craft in both the classroom and the courtroom setting.
Thank you so much. It's been a wonderful panel. To our panelists.